And Ruth, I'll trust that you'll let me know when we're ready.
Someone think 1 minute. I'm just talking.
We're all good. Thank you.
Okay, perfect. Thank you. Commissioners will begin with agenda item with the executive session consent calendar items 50 through 53. And Vice Chair Fiscom, I'd welcome
Mr. Chair.
Let me ask first, anybody need to remove anything from there? I guess it's a little bit too late since we're already in, but seeing none, Vice Chair Fiscom, go ahead.
Mr. Chair, I hereby move that the commission approve the executive session consent calendar as presented for the meeting on September 13, 2024.
Thank you. Commissioners, any comments? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscom,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Okay, thank you. We'll now move on to agenda items 54 through 58, and I understand Attorney Leonie Reeves will be appearing on behalf of the respondents on those items. Actually, I guess Heather Book might be attending. So let us know when we're in. Hello, Ms. Reeves. How are you today?
Good morning. I'm well, thank you.
Thank you for being with us. And I'm sorry if I'm saying this incorrectly. I see Miss, is it Butch, or how do you pronounce your last name?
Buck, thank you.
Buck. I'm sorry for mispronouncing that. So welcome to you both. My name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission. And we understand that Ms. Reeves is representing, I'll just refer to agenda items 54 through 58, and Ms. Buck is attending herself. But I understand that Ms. Reeves will be speaking on behalf of all the respondents in those agenda items. The way that we'll proceed here is we will first have a report by Investigator Pacheco. At that time, the commissioners may have questions of him. After that, then we will allow Ms. Reeves to present. We have a long agenda today, so we do ask that you be precise and concise with your presentation. Then we may have some questions of you as well. And then after that, we will make a decision whether we will proceed with an investigation or not, and that's how we'll proceed. So with that said, Investigator Pacheco, please.
Thank you, Chair Lindsay and Commissioners. This is Investigator Daniel Pacheco for the record. All members concerning this case have waived confidentiality and are represented by their legal counsel, Ms. Reeves. Agenda items 54 through 58 in your meeting books are preliminary review reports for the Lane County Board of Commissioners. The central issue in this case was whether the board violated public meetings law by failing to provide public notice that identified the statutory authorization for its March 13th and March 20th executive sessions. Based on the meeting materials, the executive sessions were not held in conjunction with the regular meetings, but on the preceding dates. In addition, it appears that at the end of those regular meetings, the board provided a read-in with the statutory authorization for the executive session, and then the meetings were adjourned. In such a case, doing a read-in at a regular meeting for a future-only executive session is insufficient to apply with the statutes without also complying with RS 192.640 sub 2, which requires public notice of an executive session only meeting. The effect of the violation is that the board failed to provide adequate notice to members of the public. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that the Lane County Board of Commissioners violated public meetings law by failing to identify the statutory provisions for their executive sessions. Should this case move to investigation, commission staff would offer a stipulated final order and propose a letter of education. The recommendation in your books is to move this case to investigation. Thank you.
You're muted.
Thank you. Thank you, Investigator Pacheco. First question from me. As I've reviewed the document, it appears to me that it was a simple failure to cite the statute. Have I summarized that sufficiently?
Yes, that is correct.
Okay, thank you. Commission, looks like Vice Chair Fiscom, go ahead. You have a question.
Thank you, Chair. Just a quick question for our investigator. On page 237, if that's the right page, I do note a paragraph that mentions what you would do next. What are we to move forward? Can you summarize that for us orally, please?
Yeah, of course. Thank you for the question, Vice Chair Fiscom. So based on the information, we wouldn't really investigate anything further. We have enough information to propose a stipulated final order with a letter of education.
So there's nothing more for, if I can amplify that, help me, there's nothing more for you to actually, quote, investigate or review, unquote, but move to the final conclusion.
That is correct.
Am I right? Thank you for that. Thank you, Chair.
Well, and again, I guess this is my question, and I'm sorry for if we've already addressed this multiple times. It could be feasible that we could move not to investigate and direct staff to send a letter of education, or would that letter of education only be could only be directed if we were to move to investigation?
So for it to be a letter of education, you would need to move it to investigation. We could issue a letter of advice, but
Right.
The one thing to keep in mind is having the stipulated final order and the letter of education establishes that there was a violation, and then in the future, should they engage in the same actions, it would be relevant to what the penalties or sanctions would be from future violations.
Right. Thank you. Thank you for that clarification. All right, commissioners, any additional questions for Investigator Pacheco? Seeing none, Ms. Reeves.
Thank you, Chair Lindsay, Vice Chair Fiscom, Commissioners and staff. Good morning. My name is Leonie Reeves. I'm an attorney with Miller Nash, and I am here on behalf of the Lane County Board of Commissioners, Chair Lori Trieger, Vice Chair David Lovell, and Commissioners Pat Farr, Ryan Senega, and Heather Buck. As Chair Lindsay has already indicated, Commissioner Buck is present this morning and may also wish to address the Commission briefly if the Chair were to allow it. We understand that Investigator Pacheco has completed the preliminary review of the complaints. We greatly respect the work of the Commission and the staff, and I want to assure you that the county and all commissioners take the public meetings laws very seriously. It is the county and the Commissioner's intent to honor both the black letter and the spirit of the public meetings laws. As sort of explained already, the one issue that raises a potential violation is a technical notice requirement, meaning that there were issues with how the executive session meetings were noticed for two particular executive sessions that occurred on March 13th and March 20th, 2024. The facts really aren't in dispute here, and I appreciate the investigators note that really further investigation is not warranted in this case because the facts really aren't in dispute. I will note that the two meetings were noticed in the same manner that the county has been noticing its public meetings for some time. This is a historical practice that predated some or all of the current commissioners. Until now, we weren't aware, and there hadn't been any concerns raised about the way the meetings were being noticed. As soon as the county received the preliminary reports pointing out that this may be an issue, the county changed the way it issues its public meeting and executive session notices going forward to ensure full transparency and compliance with the public meetings laws. We understand that this does not excuse any noncompliance and that the responsibility falls on the county acting through its commissioners to ensure that the law is followed. We would respectfully ask the commission to consider that the counties and the commissioners' swift actions to remedy any technical notice issues as compliance, which would make additional investigation, a formal investigation, and a letter of education unnecessary. We would certainly welcome a letter of advice and have every intent to continue to practice the notice in a way that is fully transparent and compliant with the public meetings laws. If the commission does decide to move forward, we would note that Commissioner Senega was not present at the March 20th meeting, so we would request that he would not be included in moving forward with a formal investigation with respect to the March 20th meeting. And, you know, all of the commissioners are interested in sort of wrapping this issue up in the most expeditious way. We don't believe any resources need to be further expended on what we consider to be a minor technical violation that has been swiftly corrected. So on behalf of the Board of Commissioners, I want to thank you for your time and opportunity to address the commission. I'm happy to answer any questions.
Yeah, thank you, Ms. Reeves. Yeah, real quick question. Does the commission generally have an attorney present in all the meetings or just on call from time to time?
Chair and commissioners, so the county counsel's office currently has a vacancy in their county counsel position. I'm filling in an interim role. My practice is that I attend the commission meetings as much as my schedule allows. And since I was retained in March, I have been present, or a colleague at my law firm has been present for all of the meetings since we have been retained to fill that role.
Thank you. Thank you very much. Commissioners, any questions of Ms. Reeves? And please note, I am going to ask or offer Commissioner Buck to share something if she'd like. But before we go to Commissioner Buck, Commissioners, any question of Ms. Reeves? Seeing none, Commissioner Buck, go ahead, please. Welcome.
Good morning, Commissioners and Chair. My name's Heather Buck. I'm Lane County Commissioner for District 5. I'm not the chair of our board, so I can't speak on behalf of the board, but I'm here to speak on behalf of myself. Our board is quite diverse, diverse backgrounds, different political affiliations, but I know all of us to really fully embrace the transparency of all of our meetings, including our executive sessions. The practice of our county council and administrative staff to notice our meetings predates before I came on the scene 6 years ago. We have not necessarily received any concerns or complaints about how we were noticing our meetings until this point. We know that we are responsible for those meetings. We've taken every chance to change and adjust as this came to our knowledge. And we hope that you know that there was absolutely no malicious intent behind anything. It had been our practice that on our Tuesday board meetings, if we had an executive session the next morning, that we would read it in that day and start up our meeting the next day. We absolutely have adjusted and just wanted to appreciate this being brought to our attention and know that we will make every effort to be as transparent to the public as possible in the future. Thank you.
Commissioner Buck, thank you. Really appreciate it. Commissioners, any questions of Commissioner Buck? Okay, seeing up, we see Commissioner Burke. Go ahead, please.
Yes, thank you very much, Mr. Chair. I don't have any questions. I was going to simply make a motion that we direct staff to issue a letter of advice to the Lane County Board of Commissioners.
Thank you. Thank you. I have a motion on the table. Commissioners, any comments on with respect to Commissioner Burke's motion?
I'd like to get some clarification. So, Director Myers, if we were to do a letter of advice, would that remain associated with any kind of file for these cases? Would there be a way to see if there was another occurrence that a letter of advice had been issued? And would that have any ramifications on a potential future investigation?
So a letter of advice would have no, under the penalty matrix, a letter of advice has no bearing on, on past events. The advice is for future education. So in the future, please notice your executive sessions this way. But it would not count toward any future penalties if they got into violation again. The other thing I would like to clarify for the chair and everyone is Commissioner Burke's motion to issue a letter of advice isn't a motion to resolve this case. You're still going to need a separate motion, whether to either dismiss or move to investigation. So.
Thank you.
Okay.
Thank you, Director Myers. And considering that, Commissioner Burke, do you want to revise your motion considering that, or do you want to keep your motion as is?
I would like to add to my motion, if it's allowed, that in addition to the letter of advice, that this otherwise would close the issue or the charge would be
Dismiss the
dismissed.
case? Okay.
Yes, that's
Thank
right.
you. Commissioners, any other questions or comments on Commissioner Burke's motion?
Yeah, I'm going to just pop in. This is Commissioner Newell, but we've talked a lot in this group about treating similarly situated individuals similarly. We see a lot of very technical violations. While I'm absolutely appreciative that immediate action was taken, this probably will not happen again. In many other cases, we have moved forward with a letter of education. So I'm going to be a no on the motion when it comes my way.
Thank you. I'll speak to Commissioner Burke's motion. I see you have your hand raised as well, Commissioner Burke. I just want to speak to your motion. I agree with Commissioner Newell, and Director Myers is somewhat persuasive. I agree it's a technical violation. I really appreciate what the commissioners did in resolving it quickly and being open and transparent. But I do think there needs to be essentially a paper trail, reduce this to writing. And so I'm inclined to be a no, but I'm happy to hear Commissioner Burke, you have your hand raised.
Sure. This isn't the hill I really want to die on. My motive for bringing this motion forward is because it will save us a lot of time. It'll save the investigators some time for what is a technical motion. And I do agree that we need to try to be consistent in how we deal with various entities that have technical violations. But not every entity is the same. Lane County is a larger, it's a larger county with a significant population, a sophisticated board of commissioners, a sophisticated staff. It's not like it's a very small town where they're, they have fewer professional staff, inferior record keeping, those sorts of things. And I believe that given the nature of Lane County, given the nature of the violation, I think it just saves everyone time. It saves resources just to say, you did a bad thing. You acknowledge you did a bad thing. Here's a letter of advice so you don't do the bad thing again, and let's move on. But it's fine. I mean, I understand the other point of view as well.
Thank you. Commissioners, any other comments on Commissioner Burke's motion? Seeing none, we'll call for the vote.
Commissioner Newell,
No.
Commissioner Fiska,
No.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCauley,
No.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Chair Lindsay,
No.
motion failed 2-6.
Thank you. Seeing that, Vice Chair Fiscum or any other commissioner have a motion to make?
Mr. Chair, I'm happy to proceed with a quick little preamble, which is that I appreciate our executive director's comments on this kind of issue. That's number one. Number two, I wish we had the ability as a commission to resolve the letters of education when indicated as part of a preliminary review, not in a follow-up investigation. That's just my long-held view. I will state that for the record, and then I will make this motion, Mr. Chair. Thank you for the freedom to comment before I do so. I hereby move that the commission find there is a substantial objective basis for believing that respondents, the first respondent, Ms. Lori Traeger, however you say that name, may have violated ORS 192.640 sub 2 and ORS 192.660 sub 1, and that the commission should investigate accordingly.
Thank you. I'll go ahead and make a comment. I'll support this motion, and Commissioner Burke, I'm nearly 99% in agreement with you, but the other reverse of it is because of the size of lane. That's why I do support the more formal procedures because of the size of lane. So that's where I'm at. I'll be supporting that, and obviously strongly recommend that the staff provide a letter of education as they've suggested. Any other comments on
It's all good.
Vice Chair? Seeing no comments, we'll call for the vote.
Commissioner Thompson.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiskum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke.
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
That was agenda item 54, correct?
Correct.
All right, we'll move to agenda item 55, but please remember that what Ms. Reeves said about Commissioner Sniga, that he was not there. So in my mind, Vice Chair Fiskum, I think that would be a nice one to dismiss.
Chair Lindsay, can I ask for a clarification? We have two meeting dates, March 13th and March 20th, as possible violations. And it sounds like Commissioner Siniga was present for one, none. Can we?
Ms. Reeves, would you answer that?
Certainly, Chair Lindsay and Commissioners. Commissioner Senaga was present for the first meeting, but was not present for the second meeting on March 20th.
Okay, thank you.
Thank you.
Chair, can I ask a question? The
Go ahead.
violation is for a technicality regarding noticing a meeting. So can I ask a question why being present at the meeting would somehow absolve the commissioner from a violation regarding noticing a meeting?
It was actually, to clarify, it was providing notice at that meeting to go into executive session. Actually, it was failing to cite the executive session statute. And go ahead.
And wasn't it done at the prior public meeting, but the day before going into executive session? So was he not present at that public meeting the day before?
That is correct,
Yeah.
Commissioner Payne. Commissioner Senaga was not present that entire week.
Okay, thank you for that clarification.
So I guess now I'm a little bit confused. There are two meetings. One, he was present, one, he was not. Both of them failed to cite the statute. Is that correct? I'll ask him. Okay. I see a head nod from Director Myers. So is the recommendation that we still proceed to move to investigate possible violations because there was at least one meeting? Is that correct, Investigator Pacheco or Director Myers?
Yes, Chair Lindsay,
Okay.
that is correct.
Got it. Thank you. Commissioners, any other questions, or does that give you enough, Vice Chair Fiskum?
It does, Mr. Chair, if I don't see any other hands. So that said, I hereby move that the commission find there is a substantial objective basis for believing that Ryan Seniga may have violated ORS 192.640 sub 2 and ORS 192.660 sub 1, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments? Seeing none, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke. Commissioner Burke,
Aye.
Commissioner
Aye.
Thompson,
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Vice Chair Fiscum.
Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that Mr. Pat Farr may have violated ORS 192.640 sub 2 and ORS 192.660 sub 1, and that the commission should investigate accordingly.
Thank you. Commissioners, see no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Vice Chair Fiscum, agenda item.
Mr. Chair, I hereby move the commission find there is a substantial objective basis for believing that David Lovell may have violated ORS 192.640 sub 2 and ORS 192.660 sub 1, and that the commission should investigate accordingly.
Commissioners, seeing no comments, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you.
Mr.
Vice Chair
Chair,
Fiscum.
I hereby move that the commission find there is a substantial objective basis for believing that Heather Buck may have violated ORS 192.640 sub 2 and ORS 192.660 sub 1, and the commission should investigate accordingly.
Thank you. Seeing no comments, we'll call for the vote, please.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Ms. Reeves, thank you for being with us today. And Commissioner Buck, thank you as well. We really appreciate the transparency and absolutely your service, your public service. And as indicated, this is going to end up in a letter of education, and that's about it. And you can put this in your rearview mirror. So thank you, and wish you have a wonderful day.
Thank you so much.
Thank you. All right, Commission, we're now moving on to agenda item 59, and we'll wait for Attorney David Symes. Is that how you say his name? Symes?
I believe so.
Bye.
Attorney Symes is joining us by phone.
Okay, thank you. Hello, Mr. Symes, are you on the phone? Can you hear me?
Hello?
Yes, can you hear me, Mr. Symes? This is Chair Sean Lindsay of the Oregon Government Ethics Commission. Can you hear me?
I can, Chair. Yes, I can.
Thank you. Thank you for being with us. As I said, my name is Sean Lindsay, and now is the time to hear the matter before us regarding respondent June Vining. And we understand that Ms. Vining is not attending and that you will be appearing on behalf of her.
That is correct.
Thank you. Procedurally, what's going to happen is we're first going to hear from Investigator Walker on this matter. Commission may have some questions of the investigator, and then it'll be your opportunity to respond. We do have a big, long agenda today, so we ask that you be concise in your response. And with that said, we'll proceed with Investigator Walker. Go ahead, Investigator Walker.
Thank you, Chair Lindsay and Commissioners. For the record, this is Monica Walker, investigator for the Commission. Agenda item number 59 in your meeting books is a preliminary review report for an ethics case involving June Vining, former Employee Assistance Program Coordinator for the Portland Fire Bureau, herein called Bureau. It should also be noted that a notification of representation and additional information was received yesterday from Mr. Sines, attorney for Sines Law Office, and forwarded to the Commissioners. As the deadline for the preliminary review phase had passed, staff was unable to review and include the information in the preliminary review report within your books. The complaint filed with the Commission alleges that Ms. Vining may have used or attempted to use her official position for personal gain or failed to declare a conflict of interest. From the information submitted, Ms. Vining was employed by the Trauma Intervention Program, also known as TIP, while she was employed by the Bureau. Ms. Vining retired from the Bureau in 2021, but currently still works for TIP in the capacity of Executive Director, and she has held this position with TIP since 2003. Ms. Vining conducts her TIP work in an office space owned by the Bureau. Upon commencing her employment for the Bureau, Ms. Vining was issued a phone, a pager, and a take-home vehicle to conduct her Bureau assignments. For the vehicle, the Bureau deducted $60 a month from Ms. Vining's monthly paycheck in order for her to keep the vehicle at her residence for use in traveling to and from her home to her Bureau-assigned work sites. The time period within the Commission's 4-year jurisdictional period in this case is limited. The complaint was filed on May 29, 2024. Therefore, the period relevant to this case would be May 29, 2020 through January 2021. Allegations in the complaint assert that Ms. Vining violated the use of office provisions by holding and conducting the work of her 2 employment positions simultaneously, as well as used the Bureau-issued vehicle for travel and to commute to and from both jobs without first declaring a conflict of interest. In the documentation gathered and received, Ms. Vining acknowledges that on occasion her positions overlap and that she had used the Bureau-issued vehicle for TIP-related travel and other non-Bureau business. Ms. Vining also asserted that she always notified and received permission from the Bureau's fire chief to do so. This authorization, however, appears to have only been verbal and not in writing. There is no documentation in the materials received that confirms the use of the Bureau's vehicle or equipment for personal use or TIP assignments and projects was part of Ms. Vining's official compensation or employment contract with the Bureau. Nor is there anything in the materials to support that Ms. Vining provided any written notice of her conflicts of interest. Thus, with the information available, it appears Ms. Vining may have been using the Bureau-issued vehicle for her personal benefit and for the benefit of TIP, a business with which she is associated, potentially violating ORS 244040 sub 1 and ORS 244120 sub 1 sub C. Based on the information received during this preliminary review, it appears there is substantial objective basis in this case to believe that a violation of the prohibited use of office and conflict of interest statutes may have occurred. Therefore, the report in your meeting books recommends moving this case to investigation.
Thank you, Investigator Walker. Commissioners, any questions of Investigator Walker? Vice Chair Fiscom.
Thank you, Mr. Chair. A couple questions. First of all, for the record, I would like you to verify again that Mr. Symes' letter that you gave us by email. Thank you for doing so. Arrived after the 60-day period for preliminary review.
Yes.
It did not arrive in time for you to review it officially for our benefit. Am I right?
Correct.
Thank you. Do you know how late it was?
Came in yesterday.
That's several days beyond the 60 days. I mean, roughly speaking, just do an estimate.
Yes.
But that's fine if it's several days late is my point, if that's fair.
Yes, just one moment. I can answer the question.
Thank you.
Thank you. Commissioners, any other questions of Investigator Walker?
The preliminary review period statutory end was July 27th.
Thank you. Thank you, Mr. Chair.
Commissioner Newell.
In looking at the information that's contained in that letter and in the attachment, does that change your analysis at all? Or would it?
At this time, since it was received afterwards, I am not privy to consider it. It was forwarded to the commission because the commissioners can consider it. To answer your question, I believe it would not. The information received does not show that the contract includes any information on the fact that the equipment and the vehicle could be used for TIP.
Thank you.
Thank you.
Thank you. Commissioners, any other questions of Investigator Walker? Seeing none, Mr. Symes, go ahead, please.
Thank you. David Symes for the record. And I do admit that the letter was late. I was retained on Wednesday night, so I did what I could to get it as quickly as I could to the commission and to Ms. Walker. 2 points. The information I supplied does change the analysis significantly because the information I supplied includes an attachment that shows the Bureau's contract with TIP was extended and covers the jurisdictional period. In the preliminary report, Ms. Walker says that she didn't have that information, and because she didn't ask, but that because she didn't have that information, it appeared that there might be a conflicted position with respect to the equipment and office. That's just not true. The contract was extended, and TIP has operated out of the Bureau since 1992. So it does change the analysis drastically. Another point that I would make is Ms. Walker in her report and just now in her summary says that Ms. Vining essentially admitted to conflated use of the car. When I say conflated, I mean somehow using the car for TIP purposes. And there is no evidence of that. Ms. Vining was asked very generalized questions to which she did her best to respond. The questions covered essentially a 20-year period. Sorry, is somebody trying to talk? I apologize.
No, go ahead.
Okay. And so there is no evidence in this record that during the jurisdictional period of May 30th, 2020 to January of 2021, which is when Ms. Vining retired, that she did any car-related conflated usage. There's just no evidence of that. There was a generalized statement Ms. Vining made in the investigation that she essentially couldn't remember doing that, didn't think she did, but maybe she did, it was possible. That's what she said. But that was over a 20-year period, not the last 4 months. Had the investigation focused properly on those last 7 months, from May of 2020 to January of 2021. Had the investigation properly focused on that, the commission would have been informed that the vehicle that she was given as part of her Bureau duties was an electric vehicle that was required to be charged at the station, at the Bureau. And so she hardly used it. I can't quantify what that means right now, but it does mean that there's no real evidence of any conflated use during the jurisdictional period. And my concern is that once we go past this point, this becomes, as I understand it, this matter becomes essentially a public matter. And I think before Ms. Vining's very stellar, long-standing reputation as a very exceptional advocate for our community, before it's tarnished and stained in any way, we really ought to have a better investigation. I don't know if that means we can go back into the preliminary review phase. If necessary, I would consent to do that. But at this point, there's no evidence of, and candidly, not even any allegation of what I keep calling conflated vehicle use in the jurisdictional period. So I just don't think, I think under those circumstances, this really this charge ought to be dismissed. But if we really want to do some more digging before dismissal, I would recommend we do that before going public, so to speak. Thank you.
Sure. Thank you, Mr. Symes. Commissioners, any comments or questions, I should say, Mr. Symes? Okay, seeing none. Mr. Symes, at this point, the commission needs to make a decision whether to dismiss the case or proceed. We really don't have a choice. It's either go forward or backwards. Commissioners, I actually agree with Mr. Symes that there does need to be a more thorough investigation. And the only way to do that is to proceed with an investigation as the staff recommends. Candidly, I think there's plenty of opportunity for Ms. Mining to provide a lot of this information and answer a lot of things, and it just came in too late. And so I for that reason, I would support a motion to move to investigate. I see Commissioner Payne has her hand raised. Go ahead, Commissioner Payne.
Thank you, Chair. I just want to comment on the thorough work of the investigator at this point, and just comment on, I think, what may be a misunderstanding of our procedure so far at this point. This was a preliminary review phase. It's not the investigation phase. And at this point, I just want to clarify that the work of our commission is to not decide whether there has been a violation at this point, but just to decide whether we are going to undertake an investigation to decide at a later point whether there has been a violation. And I think there were some pretty significant criticisms in Mr. Symes' letter of an investigation, but there has been no investigation at this point. There has been just a preliminary review at this point. And I just want to compliment our investigators' work, because I think that there were some pretty heavy criticisms, because I think there was just simply a misunderstanding of our procedure at this point, which we haven't done subpoenas, we haven't done an investigation at this point. We're just simply deciding whether we're going to move to the investigatory phase. And I think it's really important to understand what procedural phase we are actually at this point, so that we don't improperly criticize our investigator who hasn't completed that investigation.
Thank you. Vice Chair Fiscum, do you have a motion?
I do have a motion with this. Again, if you allow me, Mr. Chair, a quick preamble, subject to the vote we need to take yet on a motion I'll make. If we do move to an investigation, one point our chair makes to anybody who appears before us is that we are not deciding, if we take that action, that there has been an ethics violation. I want to associate my remarks with Commissioner Payne. We are investigating after doing a review, and so there's no violation, and that's important for everybody to understand, those who watch us in action, the media who reports us, as well as those who are affected by our action. So that said, Mr. Chair, I hereby move that the commission find there is a substantial objective basis for believing that, June Vining has violated ORS 244.040 sub 1 and ORS 244.120 sub 1 sub C, and that the commission should investigate accordingly.
Thank you. Commissioners, any comments on the motion presented to us? Seeing none, we'll call for the vote.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye. I think I missed something. I think I heard
Sorry.
that it passed. Correct. Okay.
We're just double checking the commissioners listed on the roll call. We think there might have been a typo, so we apologize.
No, okay, Commissioner Newell.
Aye.
Okay, motion pass 8-0.
Okay, thank you. Mr. Symes, thank you for being with us today. Again, we have not decided on any violation. We have simply decided to move forward with an investigation. Staff will be in contact, and we appreciate you being with us today.
Thank you for allowing me the opportunity.
Thank you. All right, commissioners, we're now moving on to agenda item 60. Please note that 60, 61, 62 are related, but the respondents have not waived confidentiality. So what we're going to do is we will hear them separately, excuse them after they present, and then we'll come back and decide on all three at the same time after they've been heard and after we've been able to consider. Go ahead.
We will
Susan.
decide all three one by one. So consider all three, listen to all three, don't discuss what one says in the other one. And then go back and vote on number one. Then kick it. We will invite them back in for the vote on their individual case.
Mr. Chair, I would just add a quick comment that you may know this, but Mr. DeYoung is in our actual lobby, not the virtual lobby, and he's aware of this procedure as explained to him by our staff. So thank you.
Perfect. Thank you, Vice Chair Fiscum. Okay. Let me just make sure I've got this. Young. Okay. So let's go ahead and we'll invite, how do you say his last name? Bartschiger?
Sugar.
Okay.
Bartschiger.
Your guess is as good as mine.
Okay,
Eric Sugar.
he's joining now.
Okay. Hello, Commissioner Bartschiger. Are you there?
I am here and I will turn on the All right, you should be able to see me and hear me.
I can see you, and hopefully you can see and hear me. Is that correct?
Yep.
Great. Well, Commissioner Bartschiger, thank you for being, am I saying that correctly, Bartschiger?
Yeah, that's good enough.
I'm sure you've been asked that before, so thank you for your patience. So my name is Sean Lindsay. I'm chair of the Oregon Government Ethics Commission. Now is the time to hear your case before us, the matter that's before us. The way that this will happen procedurally is we're first going to hear from Investigator McIntyre, who will report to the commission. Commission may have some questions of him, and then it will be your opportunity to respond, and we may have some questions of you. And then after that, the commission will make a decision whether to dismiss or to proceed into investigation. We're not making a decision whether there's a violation. When you do respond, we do ask that you be concise in your statement. We have a very long agenda today, and so that would be helpful to us. All right, thank you. Investigator McIntyre, please go ahead.
Did we want to wait until Commissioner Fiscum returned?
Oh, I didn't, did he excuse himself? I must have missed that.
You can proceed.
Okay.
Yeah, let's go ahead.
Thank you.
Proceed.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 60 is a preliminary review for Herman Barschinger, Josephine County Commissioner. The complaint in this matter is that the Josephine County Board of Commissioners violated Oregon Public Meetings Law by holding an unauthorized executive session on April 30th, 2024. A little background. So the board originally held an open meeting on April 29th to discuss dismissal or disciplining a county employee. The board continued that meeting until the next day at the end of the April 29th meeting. Prior to reconvening in open session on April 30th, the board held an executive session, which is the potential issue in this matter, and they held that executive session under ORS 192-660 subsection H, which authorizes an executive session to consider information or public records exempt by law from public inspection. In this case, that was a legal memo that was provided by the county's attorney. That legal advice was related to the employee's response at the April 29th, 24 meeting, and it outlined the options available to the board and risks that were associated with each course of action. Based on the information gathered during the preliminary review, it appears that the board may have exceeded the scope of what was authorized under 192660 subsection H by discussing more than just the contents of the legal memo. For example, one of the parties that I spoke to who was not a party to this case was just at the executive session. Community Development Director Mark Stevenson. He indicated that a full-fledged argument ensued about whether to terminate the employee or to conduct a 21-day investigation after the attorney provided their legal advice. Another individual that I spoke to, Stephanie Watson, Josephine County Legal Secretary, she indicated that the discussion centered around each commissioner's personal opinions on the options provided. And lastly, the executive session lasted appears to have lasted over 1 hour, while the ensuing open discussion or open meeting lasted less than 3 minutes. As such, it does appear that the board may have used the executive session to discuss the discipline or discharge of the employee, despite the employee's request to have an open hearing. And therefore, based on the information available during this preliminary review, there does appear to be a substantial objective basis to believe that Herman Perschinger may have violated ORS 192.660 at that executive session on April 30th, and therefore the recommendation is to move this case to investigation.
And you might be going there, Susan, but Investigator McIntyre, if we were to move to investigate, what would you seek to investigate? Who would you seek to visit with?
Well, I would need to speak with multiple commissioners who did not answer any questions or provide any information regarding the meeting itself. I think that would be important. Potentially speaking with the attorney again, who was at the meeting itself, once I got a little bit more specifics. But yes, speaking to Commissioner Perschinger and then potentially some of the other commissioners as well. I did attempt to do so during the preliminary review. Information was not necessarily provided.
And a point of clarification, I know there's some other complaints, a total of 3, where I'm assuming there's additional commissioners. Were there not complaints brought against all commissioners of Josephine County, just 3 of them?
There is only 3 Josephine County commissioners.
Okay, thank you. Susan?
Just wanted to clarify, because in your presentation, you said 2H was the provision. It was actually 2F.
Okay, thank you.
Yeah.
Thank you. Commissioners, any questions of Investigator McIntyre?
Mr. Chair.
Yeah, go ahead.
Well, first of
hold on,
all,
Commissioner,
our legal staff.
Commissioner Bartzinger?
Yes.
Mr. Bartzinger? Hold on, it's not your time quite yet. The commission is asking questions of Investigator McIntyre. We'll get to you in just a second.
All right.
Thank you. Go ahead, Commissioner Thompson.
Thank you. My question has to do with, I know it's permissible under our rules to discuss and come to a consensus in executive session and then come out of executive session for the final vote. Can you talk a little bit about, I know you mentioned they talked for an hour and then their open session was 3 minutes. Is there any play there between a consensus versus a decision? How would you see that playing out?
Well, yes, but subsection F is to discuss a legal memo or legal advice, not necessarily to discuss a decision related to the discipline of an employee. So I don't believe that would qualify under that subsection.
Thank you.
Okay. Commissioners, any other questions of Investigator McIntyre? Okay, seeing none. Commissioner Bartzinger, thank you for being again with us. Now is your opportunity. We look forward to hearing from you. Go ahead.
So in my response, I didn't respond to anything said in the executive session. That's because our rules don't allow us to discuss things in executive session. However, legal counsel has said I can discuss that with the commission, so with the ethics commission. So that's why you didn't see a response in my written response to you folks. I will tell you that Mr. Stevenson is not an attorney. We have two very capable attorneys that work for the county that under any circumstances in executive session make us adhere to the topic of the session. And we all know that we can't deliberate. There was no deliberations in executive session that day. There was a lot of discussion and questions on how of understanding our options, because also our insurance company played a role into what the repercussions from the different options are. So there was a lot of discussion about that. I don't remember an argument about it, but I do remember a lot of discussion about the different options and what the legal ramifications would be on each and every option. I will tell you, coming out of that session and me making that motion, at that time, I was wondering if there was another vote, because I didn't know if I had another vote, because it takes two of us to pass anything. And so when you get a second, well, you know you probably have another vote. And so that's why when there was this asked for more discussion, I said no discussion from me. Commissioner DeYoung said no discussion from him because he knows that there's two votes. And so that's why it probably went so fast and gives the appearance that we made a decision in executive session. We did not we did not deliberate, and we did not make a decision in executive session.
Thank you. I do have a follow-up question for you. You were talking about insurance. Was insurance part of that legal memorandum?
The insurance gives us guidance on what they perceive the legal ramifications can be from our decisions.
Okay, thank you.
And that would be a question for our, the communication between the insurance company and legal counsel. I never seen any written communication. I'm just going by what our counsel has stated to us and what guidance our counsel has given us.
Sure. Actually, I do have a follow-up question for either Sean or for Susan. That's interesting that Commissioner Bartzinger said that any response to Investigator McIntyre may not be disclosed from executive sessions. Could you just address that really quickly and refresh us on that? I'm assuming that they can share everything openly with Investigator McIntyre, and that's just fine.
Yes, the commission has a specific statute saying that a public body, a governing body may provide information or records from an executive session to the commission. And then as we write our reports, we of course keep that in mind in how we phrase or disclose any information in the reports.
Right, thank you. All right.
Yes, Mr. Chair, I am aware of that now. I was not aware of that when I did my written response.
I appreciate that. And hey, look at me. I'm the chair of this commission, and I had to be reminded as well. So there you go.
We live in a complicated world.
Right. Commissioners, any questions of Commissioner Bartzinger, please? Okay, seeing none. Commissioner Bartzinger, we're going to push pause on your matter. We're going to excuse you, and then we're going to call you back here shortly. We're going to move on to a different matter, and we'll come back here momentarily, and we'll call you back in when we're ready to make a decision, okay?
Thank you.
Mr. Barshinger, I'm sorry to interrupt. Just to let you know, unfortunately, the system is going to require us that we actually remove you from the meeting. So if you rejoin the link, you will join the waiting room, and when we're ready to bring you back in, we will do so.
Okay, you want me to do that right away as soon as you get rid of me? You want me to ask to join again?
That would be wonderful. Thank you. Thank you.
All right, got it.
Okay, thank you. All right, staff, please tell me when Commissioner West is in.
Okay, so Commissioner West and Connor King for Commissioner West are joining us for item 61.
Thank you. Hello, Commissioner West. Welcome. And Mr. King, are you online?
I am, yes.
There you are. Nice to see you again, Mr. King. So, Commissioner West and Mr. King, my name is Sean Lindsay, Chair of the Oregon Government Ethics Commission. We are, now is the time to hear the matter regarding you, Mr. Commissioner West. What we'll do procedurally is we'll first hear from Investigator McIntyre, and then after that, we may have some questions of him, and then it will be your opportunity to respond. Mr. King, will you be speaking only for Mr. West, or will both of you be speaking?
I'm going to be speaking. I don't know if Mr. West might want to add comments after I'm done, but that'll be up to him.
Thank you, and we'll let you make that decision. Our only request is we have a super long agenda today. We ask that you be very concise in your response when it's your turn. All right, thank you, Commissioner or Investigator McIntyre, please.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 61 is a preliminary review for John West, Josephine County Commissioner. The complaint in this matter is that the Josephine County Board of Commissioners violated Oregon Public Meetings Law by holding an unauthorized executive session on April 30th, 2024. Little background on the matter is that the board originally held an open meeting on April 29th, 2024, in order to discuss dismissing or disciplining a county employee. The board continued that meeting until the next day. Prior to reconvening an open session on April 30th, the board did hold an executive session, which is the potential issue in this matter. And they held that executive session under ORS 192-660 subsection F, which authorizes an executive session to consider information or public records exempt by law from public inspection. In this case, that was a legal memo provided by the county's attorney. That legal advice was related to the employee's response that they gave to the Josephine County Commissioners at the April 29th meeting, and it outlined the options available to the board and risks associated with each course of action. Based on the information gained during preliminary review, it appears that the board may have exceeded the scope of what was authorized under ORS 192-660 subsection F by discussing more than just the contents of the legal memo. For example, witness to the executive session, Community Development Director Mark Stevenson, indicated that a full-fledged argument ensued about whether to either terminate the employee or to conduct a 21-day investigation after their attorney provided their legal advice. Another witness, Josephine County Legal Secretary Stephanie Watson, indicated that the discussion centered around each commissioner's personal opinions on the options provided. And just for some context, the executive session itself lasted over 1 hour. The ensuing open session lasted less than 3 minutes. As such, it appears that the board may have used the executive session to discuss the discipline or discharge of the employee despite the employee's request to have an open hearing. Therefore, based on the information available during this preliminary review, there appears to be a substantial objective basis to believe that John West may have violated ORS 192-660 subsection 2 at that April 30th executive session, and the recommendation is the commission move to investigate. Thank you.
Thank you. Commissioners, any questions of Investigator McIntyre? All right, seeing none, Mr. King, go ahead, please.
Okay, thanks for hearing us today. I'll try to be as concise as I can, but there's a number of things I wanted to address from the preliminary report. So we know that an executive session was held under subsection 2F to consider a memorandum drafted by the county's legal counsel. That memo outlined different disciplinary options of a current employee and potential legal liability associated with that. The preliminary report acknowledges that having an executive session to review such a memo with county counsel is perfectly fine and appropriate. The preliminary report frames the issue as whether the board's discussion or deliberations during the executive session on April 30th was authorized by subsection 2F. The preliminary report goes on to make a distinction between the term consider and as used in 192.660 and deliberations as defined in 192.610 sub 3. This is as far as I can tell, this is a distinction without a difference. Deliberations is defined as discussions or communication that are a part of the decision-making process. The term consider is not defined, but in the regulations associated with the statute, it associates the word, it talks about consideration being a discussion. And in a case or in a situation like this, considering a memo like this, discussion is going to be related to a decision-making process. The preliminary report suggests the commissioner's discussion should have been limited to legal advice and questions related to the attorney memo, and suggests that discussion took place outside of that. In my opinion, I'll go through just a couple of items that I think are issues with the analysis in the preliminary report. First, as already discussed, consider is not defined, but presumably covers a discussion or communication that is a part of the decision-making process. Second, and this is an important point, in the Attorney General's Public Records and Meetings Manual, which is provided by the DOJ, it specifically states that when executive sessions are held for consideration of legal issues and consulting with legal counsel, and this is a quote from the meeting manual, says the discussion in executive session may proceed even to the point at which the governing body has reached an informal consensus as to its course of action. However, any final decisions must be held or must be made in open session. And that's what happened here. There was an open hearing on April 29th because the employee requested it. There was an executive session on April 30th. The discussion, as noted in the meetings manual, can go all the way to the point of reaching an informal consensus. And then the executive session was closed and an open meeting was, the open hearing was reopened for a final decision. Third, even if Mr. Stevenson accurately described the details of the executive session, the discussion that occurred was fully within the bounds of what's permitted under 192.660. The remarks that Mr. Stevenson made to the commission staff were that the meeting had to do with the memo that was provided to the board of commissioners by county legal counsel, which outlined different disciplinary options of a current employee and the potential liability related to that. And he said that the subsequent discussion was a discussion about the legal memo, arguing about what the correct action was going to be, whether to terminate or do a formal 21-day investigation, basically consideration of those different disciplinary options. So even with Mr. Stevenson's statement, that's fully within the bounds of what's permitted under the statute and the associated regulations. And then finally, the report mentions that there is I guess we already discussed that, but there was an open hearing and it was requested, and the executive session was simply to consider something that the preliminary report has already identified as appropriate, the legal memo and consulting with legal counsel. So basically, just in sum, kind of to summarize it all up, the board wished to consider the termination of an employee. Employee requested an open hearing. Open hearing was held on April 29th. The county's council drafted a privileged legal memo which concerned potential disciplinary action that could be taken, including termination, and the consequences of taking that action. The legal memo was considered and discussed during an executive session on April 30th. According to Mr. Stevenson, the discussion included a conversation about what kind of disciplinary action should be taken, which was the topic of the legal memorandum. And then following the executive session, the hearing was reopened, at which time a final decision was made terminating the employee. So it's pretty clear to me that no violation occurred, but that's the end of my comments on the matter.
Thank you. Appreciate it, Mr. King. Staff, any questions of Mr. King? Okay, Commissioner West, did you want to say anything, or are you good with what Mr. King has said?
I'm good with what Mr. King said. Thank you.
Okay, thank you for being with us. All right, Mr. King and Commissioner West, we're going to excuse you now. We're not going to make a decision. At this point, we're going to push pause on your matter. We'll excuse you, and then we'll invite you back momentarily when we're prepared to make a decision. Okay, we're going to hear another matter, and then we'll come back to yours. Okay.
Okay. Thank you.
Thank you.
Commissioner West and Mr. King, unfortunately, the system is going to require us to remove you from the meeting. So once we've done that, we just ask that you click on the link and rejoin. You'll join the waiting room. And when the commission is ready to invite you back in, we'll bring you back in.
Thank you.
Okay, thank you.
Thank you.
Commissioner Lindsay, Investigator McIntyre is getting the next respondent.
Thank you.
Yes, sir.
Hello, Commissioner DeYoung. Am I saying that correctly?
Yes, you are.
Okay, welcome. Thank you for being with us today. I'm sorry I'm not there in person. My name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission. Now is the opportunity for your matter to be heard. What we'll do procedurally is Investigator McIntyre is going to report to the commission first. We will have we may have some questions of him, and then it will be your opportunity to respond. And we may have some questions of you. And then after that's done, the commission will make a decision to proceed to investigation or not. We are not making a decision today whether there's been any violation. So with that, and when it is your turn to speak, we do ask that you be concise. We have a very long agenda today, and we would appreciate your assistance in that. Investigator McIntyre, please go ahead.
Thank you, Chair Lindsay and Commission. This is Investigator Andrew McIntyre for the record. Agenda item number 62 is a preliminary review report for Daniel DeYoung, former Josephine County Commissioner. The complaint in this matter is that the Josephine County Board of Commissioners violated Oregon Public Meetings Law by holding an unauthorized executive session on April 30th, 2024. A little background is the board originally held an open meeting on April 29th, 2024 to discuss dismissal or disciplining a county employee. The board continued that meeting until the next day. Prior to reconvening in open session on April 30th, the board held an executive session, which is the potential issue in this matter, under ORS 192-660 subsection F, which authorizes an executive session to consider information or public records exempt by law from public inspection. In this case, a legal memo that was provided by the county's attorney. That legal advice was related to the employee's response at the April 29th meeting and outlined the options available to the board and risks associated with each course of action. Based on the information gathered during the preliminary review, it appears that the board may have exceeded the scope of what was authorized under 192-660 subsection F by discussing more than just the legal memo. For example, a witness to the executive session, Community Development Director Mark Stevenson, who did not see the legal memo, I want to make that point. He indicated that a full-fledged argument ensued about whether to terminate the employee or to conduct a 21-day investigation after the attorney provided their legal advice. Josephine County Legal Secretary Stephanie Watson indicated the discussion centered around each commissioner's personal opinions on the options that were provided. And lastly, for context, the executive session lasted or over an hour, and the ensuing open meeting lasted less than 3 minutes. Therefore, it appears that the board may have used the executive session to discuss the discipline or discharge of the employee, despite the employee's request to have that open hearing. And therefore, it appears to be a substantial objective basis to believe that Daniel DeYoung may have violated ORS 192660 subsection 2 at that executive session on April 30th, and the recommendation is the commission move to investigate this case.
Thank you, Investigator McIntyre. Commissioners, any questions of Investigator McIntyre, please?
No, sir. Nope, I think that he was not very accurate.
Good referencing their commission.
I'm sorry. I guess I can't call myself. Call me decommissioner if you would, sir. Thank you.
Yes, I will do that. And candidly, it's a little bit, I have tunnel vision here. It's hard to see you down there, so I didn't know who was speaking. But seeing no comments or questions of Investigator McIntyre, Commissioner DeYoung, now it is your opportunity, and we look forward to hearing from you, please.
Yes, I was part of the Board of County Commissioners during this whole process. Trish House, I guess you call her she's the employee that she had worked for alongside of myself. She worked in our board office for a little over 5 years, and she didn't have any priors or anything of that sort. And when it came down to it, there was a sworn affidavit, in fact, 2 sworn affidavits that started this process and put her, as on the chopping block, if you will. I suggested, we did have a long conversation in executive session. We did receive legal counsel's advice, I guess it was, as you could say. But at the same time, it was Commissioner West, and I don't know if it was in this meeting or executive session. He asked me, he says, well, Commissioner Young, you've been silent about this the whole time, and we've had the discussion. Do you have anything to say? And I said, well, first off, if what's in the affidavit was true, then I'm disappointed in the employee. And second is I'm more interested in what kind of a atmosphere is she working under that would make her do this. That was, I think, more important to me. But I was in the room at the time, and to be quite honest with you, I probably should have said something. It sounds to me like we're deliberating, but my anticipation was that we were going to deliberate when we got back into public session, as the Ms. House requested that everything be in the public session. We came out of executive session and we went right in. There was a motion to fire her and a second, and I said I voted no. It was 2-1 to fire her, but I did suggest that she undergo training and possibility of maybe a probationary period, anger management training, whatever it would be, and that was basically ignored. And I think I guess I would look at it as kind of a process of elimination. If you didn't deliberate after the executive session to add any length where she was present to at least rebut, if you didn't do it in public session, you had to have done it either in a private meeting or you had to do it in executive session. So, I know that I know what we're talking about here is do you folks continue with an in-depth investigation, which includes myself? And to be quite honest with you, I hope you do.
Thank you. Commissioner DeYoung, a couple of questions that I might have of you are, did you know how the other commissioners were going to vote before you went into public session?
No, I know that when I talked about, some probation or anger management, it was not accepted at all. So I was just, I kind of made the assumption that it's not really going to do me any good to go any further with it, because I
I thought that it was a foregone conclusion that she was going to go away.
Right. So would it be fair to say that the three commissioners did not come to a consensus during that executive session?
I'll say that one more time.
Is it fair to say that the three of you did not come to a consensus before you came back into public session?
We did not voice that consensus, but we'd had a lengthy discussion. That discussion lasted, that executive session lasted almost an hour. And I don't think we formally said, well, how are we going to vote? What are we thinking or anything of the sort during executive session? But when we came out of executive session, we didn't have any deliberation to speak of. Said that in my mind would qualify a deliberation to where Ms. House could respond.
Commissioners, any questions of Commissioner DeYoung that you might have? Okay, seeing none. Executive Director Myers, my understanding is that we will push pause on this and then go back to some prior matters, or can we continue with this matter and go reverse order?
Yes, you could continue with this matter and vote on this matter and then end it and go back.
Okay, well, let's be efficient here then, and I recommend that we make a decision in this matter while everybody's here.
I appreciate that. I have to drive back to Grants Pass.
Right. So commissioners, I'm going to express my thoughts here first, but I'm very interested in hearing yours. First of all, I really appreciate all these Josephine County commissioners coming, especially Commissioner DeYoung coming in person. That's pretty applaudable. Applaudable, I should say. I'm not persuaded that there was deliberation in this executive session. I think it's you know it when you see it, and that's why I've been asking some pretty pointed questions. Is what was the scope? What was the actual scope of that executive session, and did they go beyond the scope of that? I'm not convinced they did. Number one. Number two, if we were to move to investigate, I understand that Investigator McIntyre would visit with each of these three commissioners, and we have heard from these commissioners directly. And having heard that, I'm not convinced that they extended beyond the scope. Now, we could dig into it, look under every rock a little bit even more, but I think we've gathered the information we're going to hear if we were to move to investigation now. So those are my thoughts. I would support a motion to dismiss this matter, but I'm happy to hear from you. Vice Chair Fiscom, go ahead.
Mr. Chair, thank you. Just a quick question for our staff and our legal counsel. It is in part pursuant to Commissioner Thompson's comment a while ago, which is that what's the difference between a move toward consensus and deliberation or deliberation? Is there a distinction between those two terminologies, if I'm using them right?
Yeah, so one just piece of information, the AG manual was written in 2019. The statute has since changed since that manual was put out. So previously the term deliberations was not defined. It is now defined in statute. The term consideration, which was this provision related to legal advice or a memo that's exempt from public records law, consideration is not defined in statute. So to the extent that there is a difference, there is a legal difference. One of the benefits that you all get is to define those legal differences. And but there is a legal difference between those two. What that is, the commission gets to say, essentially.
Thank you, counsel.
I would add, for me, the distinction here isn't, was it deliberation or consideration? It's, Was it deliberation of the information in the memo? Was it deliberation about, here's what our attorney says our options are? Or was it deliberation about dismissing or disciplining the employee? Dismissal or discipline of the employee can only be discussed in an executive session under subsection 2B. They were not in that executive session. So it is a very nuanced question of, were they only discussing, here is what our attorney says the legal consequences of all these options are? Or were they discussing, here's what our attorney says, and here's what I think we need to do? Because that then moves it toward the 2B, which would not apply to the executive session.
Right. I absolutely agree with you. And that's thank you for clarifying that. And again, that basically even underlines my reaction here is, where do you draw that bright line between discussing the memo? It's nuanced. Why should we get our sticky fingers in figuring out that nuance? That's my position, but I'm happy to hear from other commissioners. Commissioners, any comments, or go ahead, Commissioner Newell.
Yeah, thank you. One of the things that rings here for me is that they couldn't discuss the disciplining or firing under 2B because the employee in question had requested this be done in open session. And that by getting into this nuance of were they or weren't there, they're violating the spirit of what that employee was requesting, the spirit of what that statute stands for. That when you're talking about somebody's discipline, they have the right to have that be an open hearing. So for me, that leans more towards continuing with this to see if we can find a little bit more of a bright line about whether it was, talking about what their legal options were and the consequences of those legal options solely, or whether the discussion was more about whether they should be dismissing or disciplining the employee. So I would like to find out more to make sure we're honoring that employee's rights and the spirit of the statute.
Thank you. Commissioner Thompson.
Thank you, Mr. Chair. I tend to agree with you because there's a statement in the investigator's report that mentions that the memo outlined the different disciplinary options, memo from legal counsel, the different disciplinary options for the current employee and the potential legal liability. So I think if they were discussing the memo included the disciplinary options. So if you're discussing the advice from counsel, it's in the memo. So I don't know how you would have a discussion about the memo and not discuss what the memo said. So I think you're right. I think this is a fuzzy issue, but I'm inclined to say that they were discussing the memo, even if they were also discussing the disciplinary options, because those were included in the memo.
Thank you. Commissioner Payne.
Thank you, Chair. I do think there's a difference between asking about what the legal liability is or clarifying what the consequences are if you were to take certain actions, and then deliberating about what action you actually should take. I think there is a clear line there. For instance, okay, counsel, if we were to take this action, what would be the consequences of that action? And then getting into an actual discussion of, this is the action I think we should take regarding this employee. I do think there is a clear line there, and I think that there is evidence here that substantiates or that says they may have gone into the discussion about, I think we should take action regarding this employee. And I think that does go into deliberation, and that is not about the memo about what their options are, but that goes into deliberation. And for me, I think that means we need to investigate. I think there were several people present in the meeting that says they went beyond discussing what options they could take into a discussion about what options they wanted to take. And because the employee has a right to ask for a public meeting on the latter discussion, I do think we need to investigate. That's where I'm leaning. And I think that that's a very important distinction. And the director said they went into that latter discussion. The secretary said they went into that latter discussion. And Mr. DeYoung said they went into that latter discussion. And because several people said that, I do think we need to investigate here. And I think that that's an important distinction.
Thank you. Commissioners, any other comments?
Mr. Chair, I'll just make a
Go
quick
ahead.
comment that I'm still being informed by comments from my colleagues, so thank you for those who have commented. I'm left with the pivot here for me, which is, and then help me with this if I'm missing something, investigator or Director Myers. If the employee asked for a job to be discussed in public session, and she wasn't given a public session for that to occur, then that strikes me as fairly pivotal here, even though I understand the sometimes fuzziness of having a legal memo from your attorney, which is protected under law as well as by general legal privilege for a document from your counsel. So the pivot for me tends to get back to the issue of whether the employee in question here was given a public session or not. And she asked for one, if I'm not mistaken.
Well, and Andrew might be able to answer. I believe she had been given a public session prior on the day before this executive session. The question would be, was that public session, was the deliberation of her discipline, which is part of her public session right, done in the executive session?
Thank you. Thank you, Chair.
Thank you. Commissioners, any other comments? Seeing none, I'd like to first say this has been a great discussion. This has been a healthy and productive discussion. I really appreciate, especially what Commissioner Payne said. I do agree that there's that bright line. A couple comments in response. Number one, although I completely agree with Commissioner Payne's analysis, I'm respectfully just on the other side of the line of sufficient or telling evidence. Number one. Number two, if we were to move to investigation, we've already heard what's going to be said. We've heard from Mr. DeYoung and from others, and so we're going to be back in this exact same situation a little bit later, trying to make a decision whether there's been a violation. I don't think we're going to learn substantial new information with the investigation. I think we've already heard of what they're going to say, and it's this fuzziness. And so my opinion is let's make a decision now with the information that we now have, and which is most likely going to be the exact same information we're going to have later. And then number three, I do believe that the employee did get the spirit of the law prior to going to the executive session, and even after an executive session. Now, apparently it was a 3-minute public session, but there was that opportunity to have that public session. So with that said, those are my responses. I totally respect everybody else's opinions, but I just wanted to try to articulate my reason why I'm disinclined to proceed to investigation. With that said, I think we've plowed a lot of field here. I think it's time to consider some motions. Is anybody prepared, any commissioners prepared to make a motion on this matter?
Mr. Chair, just for the record, I will yield to my colleagues on this one in light of our discussion. Thank you for your comments. So I will wait to see what happens. Thank you.
Thank you. This is a procedural question. I don't I can move, can I, as a chair? Commissioner Burke raising his hand, but I'd like to know that question, answer that question. I can move as the chair, right?
Yes.
Okay.
Yes, you can.
Commissioner Burke,
Yeah,
go ahead, please.
Yeah, it's a point of order I think I would like to know the answer to as well. Under Robert's Rules of Order, the presiding officer is not allowed to vote unless it will change the result of the vote, or in the case of a 2/3 majority, would change the outcome of a 2/3 majority. That is overridden if there are bylaws to that effect that we would have. That's my understanding of Robert's Rules of Order. I don't know how tightly we go to it, but anyway, what I wanted to do was just for the sake of kicking this off, make a motion that we dismiss.
Okay, we have a motion to dismiss in front of us. And if I can add a little bit of meat to that, Commissioner Burke, would it be fair to say you moved to dismiss the complaint and end of the preliminary review? Is that correct?
That's correct.
Okay. Commissioners, any comments on the motion before us? Any further comments? Okay, seeing none, let's call for the vote.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCully,
No.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-3.
Thank you. Thank you, commissioners. Again, I think this is healthy, good conversation. I really appreciate it. Commissioner DeYoung, thank you for being with us today. Your matter's been dismissed. The staff will be in touch with you, and we appreciate you being with us, and we'll let you get back to Josephine County.
Thank you very much. And I appreciate the commission being able to listen and hear. I'm disappointed with the outcome because it's far deeper than this one item, but maybe we'll be back here again. Okay.
Thank you.
Thank you very much. And I appreciate it.
Thank you.
Just to clarify for those of you in the room, the during that session, a member of the media did join and it's sitting in the room.
Okay, thank you. All right, let's call Commissioner Bartsinger back in, please.
Okay. Commissioner Barsinger is now joining online.
Hello, Commissioner Bartsinger. Can you hear and see me?
Yes.
Thank you. Welcome back. We appreciate your patience with us. Commission is now hearing your matter again, and we're prepared to make some decisions. And with that said, Commissioner Burke, or would you be so? Do you have a motion to present?
Yes, I move that we dismiss this case, and it would end the preliminary investigation.
Commissioners, any comments on Commissioner Burke's motion? Seeing none, we'll call for the vote.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCully,
No.
Chair Lindsay.
Aye.
Motion passed 5-3.
Thank you, Commissioner Bertzinger. This matter's been voted on by the commission to be dismissed. Staff will be in contact with you, and we appreciate you being with us today.
Thank you all, and thank you all for your service to the state.
Thank you. You have a good day.
You too.
Staff will remove him now, and staff, will you please call back in Commissioner West and Mr. King?
Okay. Commissioner West and Mr. King are joining us.
Hello, Mr. King, Commissioner West. Thank you again for rejoining with us. Commission's hearing your matter again now, and we're prepared to make some decisions here. And with that said, Commissioner Burke, do you have a motion for us?
Yes, Mr. Chair, thank you. I move that we dismiss this and end the preliminary investigation.
Thank you. Commissioners, any comments on this matter? Or on the motion, I should say? Seeing none, we'll call for the vote.
Commissioner Thompson,
Aye.
Commissioner Newell,
No.
Commissioner Fiscum,
Aye.
Commissioner Payne,
No.
Commissioner Mason,
Aye.
Commissioner McCully,
No.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-3.
Thank you. Mr. King, Commissioner West, thank you for being with us. This means that the matter's dismissed. Staff will be in touch to confirm, and we appreciate you being with us today and wish you a good weekend.
Thanks, you too.
Thank you.
Thank you.
All right, commissioners, we've been plowing ahead for an hour and 49 minutes. Let's take a 10-minute break. We'll reconvene at 11 o'clock with agenda item 63, I believe. Okay, see you at 11. Hello, everybody.
Oh.
All right, is everybody back? It looks like we are, maybe. Commissioner Payne, Commissioner Burke, Commissioner McCauley, Commissioner Mason, are you in there?
I'm back.
All right, Commissioner Burke, you there?
Yeah, it's kind of like Pink Floyd. Is anybody in there?
All right, Commissioner Payne, are you there? Can you hear us? Oh, she's there. She's usually on camera, so. All right, well, let's go ahead. We still have a quorum here, so we're now moving into agenda item 63. And this is Jenna LaBounty, former Chief of Staff of the Lane County School District. Is she here with us?
She's joining us now from the waiting room.
Especially.
Hello, Miss LaBounty. How are you? Can you hear me?
I can, thank you.
Okay, thank you for joining us. My name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission, and now is the time for your matter to be heard before the full commission. Procedurally, what's going to happen is the investigator's first going to report to the commission, and we may have some questions of the investigator, and then after that, it'll be your opportunity to address the commission. And we do have a super long agenda today, so we would appreciate you being concise as you can be. And from that, we will proceed with investigator Fenstermaker, please.
Morning, Chair Lindsay, Commissioners. I'm Casey Fenstermaker. Agenda item 63 is a preliminary review report for Jenna LaBounty, also known as Jenna McCauley, who is the former Chief of Staff for the Lane County School District 4J. The complainant in this case alleged that Jenna McCauley may have attempted to use her official position for financial gain when, as Chief of Staff for the district, she awarded a sole source contract to Terrell Group LLC, now Ms. McCauley's current employer. Information reviewed during the preliminary review indicates that Ms. McCauley obtained a quote from Terrell Group, completed the sole source justification form, and subsequently awarded a sole source contract to Terrell Group in November of 2023. The contract is valued at $100,000 for brand development services for the district. Ms. McCauley subsequently left her position with the district in May 2024 and joined the Terrell Group later that month. A public official is prohibited from using their official position for financial gain or avoidance of financial detriment if that financial gain or avoidance of financial detriment is only available because of the public position they hold. This prohibition includes using or attempting to use one's official position to create or obtain private employment or a private income producing opportunity. Given the timing of the contract award and the timing of Ms. McCauley's employment with the Terrell Group, there is a substantial objective basis to believe that Ms. McCauley may have used her position to obtain a financial benefit for herself in violation of ORS 244-040 sub 1. Additionally, a public official is prohibited from furthering their personal gain through the use of confidential information obtained in the course of or by reason of holding their position as a public official. Given the type of contract and the type of services contracted for, there is substantial objective basis to believe Ms. McCauley may have used confidential information obtained during her employment with the district to benefit her personally in violation of ORS 244.040 sub 4. Finally, a former public official may not have a direct beneficial financial interest in a public contract that they authorized for 2 years after the date the contract was authorized. Ms. McCauley appears to have authorized the sole source contract with the Terrell Group in November of 2023, and therefore was prohibited from financially benefiting from it for 2 years. While it does not appear that Ms. McCauley was working directly on the district's contract, she may have received some other financial benefit from the district's contract in violation of ORS 244.047 sub 2. Based on the information reviewed during the preliminary review, the recommendation is to move this matter to investigation.
Thank you. And Ms. McCauley, do you prefer being called, Ms. McCauley? You
That's
good with
fine.
that? Okay, thank you. Commissioners, any questions of investigator? Yeah, go ahead, Vice Chair.
Two quick questions for Investigator Fenstermaker. First, the name Colt Gill rings a bell with me. Have you identified who he is in relation to this complaint?
I believe he is with the Oregon Department of Education.
No, he was the former director of the Department of Education. He is now, I believe, the director of either the director or on the board of the school district. He retired from OGEC.
Thank you. That's helpful. The basic question, Ms. Fenstermaker, is can you be specific about what it is you would follow up on were we to move to an investigation?
Sure. So one would be the circumstances around the sole source option. There was the procurement specialist who signed off on the sole source procurement. So we didn't have a chance to speak with him during investigation. We would seek to do that. The other would be to obtain a copy of Ms. McCauley's contract with the Terrell Group to see what benefits she may have been given as part of that contract and whether or not she benefited from the district's contract through her own contract with the Terrell Group.
Thank you. Thank you, Chair.
Thank you. Commissioners, any other questions?
Yeah, I
Commissioner
do.
Newell.
Thank you. So in reading this, I had a couple of questions about, there's a lot of different allegations and points that are touched on here. One is in the using the public position to obtain a financial benefit in the form of getting the position. We have information that she was not promised a job, that it sounds like there was an open, whenever you're ready, we'll hire you kind of relationship. And can you give me more information on why that would be a substantially objective basis that she used her public position to obtain a financial benefit?
I think it goes back to the timing, primarily because she had been I won't say negotiations because I don't think it was a negotiation, but she had been in discussions with the owner of the Terrell Group for some time. And so the timing of issuing the contract versus finally accepting the position with the Terrell Group is of interest.
Okay. So even though you have, both parties saying, no, that had no factor in it, you would still investigate further?
Yes.
Okay. And so I appreciate the comment that you're getting more information on who signed off on the contract. I think that is a helpful thing to know more about. Let's see, I have another question here. You wanted more information on her involvement in the contract work. Specifically, what would you be looking for? Because we have that the Terrell Group is not doing work under this contract. She didn't do work on the contract. From both sides of this, you have information that she did not work on the contract. It wasn't part of her portfolio. So what other things are you looking for?
Right. So the financial benefit wouldn't be limited to the work that she did under the contract. It could be the fact that she received some type of benefit in her own employment contract with the Terrell Group that was a direct benefit of the contract that she awarded to the Terrell.
Can you give me an example?
So we were thinking of if there were any type of signing bonus, for example, or something that tied it back to what she had given to the award of the contract to the district.
Okay. All right. Thank you for answering those questions.
Thank you. Commissioners, any other questions of Investigator Fenstermaker? I see none. Ms. McCauley, go ahead, please. Thank you.
Thank you, Chair, Vice Chair, and Commissioners and staff. I'd like to thank you for the opportunity to speak this morning, to expand upon Ms. Fenstermaker's report and provide additional clarity to the outstanding questions that I believe will help assure the Commission that there were no violations in this matter. Before I begin, I would also like to acknowledge my appreciation for Ms. Fenstermaker for her professionalism and sensitivity. As someone who's been referred to as Jiminy Cricket by my peers for being the conscience of my organization, this is not a position I could have ever believed I'd be navigating. As Ms. Fenstermaker's report made it clear that there was no conflict of interest in the execution of the contract, nor did I work directly on the contract once joining Terrell Group, I'll keep my time brief and focused on the remaining questions of addressing the timeline of the contract execution, the events that preceded my accepting the position with the Terrell Group, as well as my compensation with the Terrell Group, so that you may be reassured that I did not nor would not leverage a public position for personal gain, nor have I received any direct benefit resulting from the contract between the Terrell Group and Eugene Fort J. First, I'd like to note that it was a not to exceed amount to be distributed based on the work as it occurred rather than a guaranteed rate or monthly retainer. To address the timeline, it's important to note that the time of execution of the contract in the fall of 23, I had no way of knowing the drastic leadership changes that would occur the following spring that would then impact my decision to leave Fort J. I executed a contract to support a district need with the approval of the then superintendent, the support of the chief business officer, and the district procurement team. There was no discussion, promises, or insinuations of potential future employment with the Terrell Group, as noted by Ms. Fenstermaker's report. At the time that the contract was executed, I had no intention of leaving Fort J. In March of 24, my employment contract with Eugene Fort J was renewed and extended, securing ongoing employment and benefits with the district at my then salary. Later in March, the district then publicly separated from the superintendent who had hired me and appointed interim superintendent Colt Gill. In late April of 2024, Ms. Terrell approached me unsolicited to let me know that she intended to fill her lead public relations role at the Terrell Group and that she'd like to offer me the position. I asked Ms. Terrell for time to discuss with my family, as the role would mean significantly less stress on my health and well-being, but would also be a significantly lower salary and absent any health benefits. While considering the offer from Ms. Terrell on May 6th at a regularly scheduled meeting, Mr. Gill notified me that there was going to be many changes in the leadership team for the coming year, including my role as chief of staff. Mr. Gill advised that I could remain at the district under my newly renewed contract in a different position or had the option to discuss separation. As I evaluated the options, I determined it was in the best interest of my family and the school district to step away from Fort J and accept the lower compensation with the Terrell Group that afforded me more time with my 4 children. I hope this information helps the Commission confidently confirm that at no time did I leverage my role as a public employee for personal gain. Finally, as it relates to any concerns regarding direct financial gain from the contract between Fort J and the Terrell Group, as Ms. Fenstermaker noted in her report, Ms. Terrell indicated that the last compensation they received from Fort J by the Terrell Group was in April. I did not begin work with the Terrell Group until May 28th and did not receive my first payroll check until June 7th. I have no ownership in the Terrell Group, nor do I have any stock or interest in the company. I am an at-will employee and I do not have a contract outlining employment, nor was I compensated in any way for the work completed by the Terrell Group for Eugene School District 4J. As a longtime public servant, I'm appreciative of a process that ensures the continued integrity of those charged with serving our public and allocating public resources. I'm hopeful that these additional details continue to confirm that there were no violations in this matter and would ask the Commission to consider dismissing and closing this case. Thank you for the opportunity to reassure you, and I'm happy to answer any questions.
Ms. McCauley, thank you, and thank you for appearing personally. We really appreciate it. Commissioners, any questions of Ms. McCauley, please? Seeing none, I think it's now time for the Commission to make a decision whether to dismiss or whether to proceed from preliminary review into investigation. Commissioners, any comments on that? Commissioner Newell, please.
Yes, thank you, Chair. I would support dismissal of this preliminary investigation today, this preliminary review. I think Ms. McCauley is a very credible witness. She's very heartfelt. She gave us detailed information about the timeline and where different people were. And even if she hadn't provided all of that extra information today, I would have been uneasy moving forward with some of the aspects of this, as there seems to have been a lot of care taken on both sides to make sure that they weren't in violation. So my personal opinion on this would be to move forward with a dismissal today and not continue the investigation.
Okay, Commissioner Thompson.
Mr. Chair, thank you. I tend to agree with Commissioner Newell. The only outstanding question in my mind after reading through this and hearing the presentation was the prohibition against working on a contract that you negotiated as a public official. But with the contract being put on hold between the Terrell Group and Eugene 4J shortly after Ms. McCauley was hired, I'm satisfied that that's not an issue. So I would support Commissioner Newell's motion to dismiss.
Commissioner Mason.
Yep, same, support dismissal of the case. Thank you.
Thank you. Do we have a motion?
Mr. Chair, if you're ready for a motion, I have one.
You got it.
Go ahead.
You got it.
No, I'm happy for you to make it,
Okay.
Commissioner.
I've got a book today.
Oh, you got it.
Commissioner
Well,
Newell,
just as a piece of friendly advice, read number 2.
All right. Thank you, Chair. Thank you, Vice Chair. I move the commission find that the complaint and information available during the preliminary review appears to be insufficient to constitute a substantial objective basis for believing that Jenna LaBounty, aka Jenna McCauley, lost my spot there, has violated provisions of ORS 244040 sub 1, ORS 244040 sub 4, or ORS 244047 sub 2, and does not warrant further review, and that this complaint should be dismissed.
Thank you. Commissioners that haven't spoken already on this, any comments? Seeing none, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye. Aye.
Motion passed 8-0.
Thank you. Ms. McCauley, thank you for being with us today. The matter is dismissed. Staff will be in touch to confirm that. We wish you a wonderful weekend. Thank you.
Thank you.
All right. Thank you. We're now moving on to agenda item 64 regarding Deborah Clark, respondent. And staff, if you'll let us know when she is in.
So, Chair, we have 2 Deborah Clarks in the waiting room, so we're going to let one in, see if it's the right one. Go from there.
Thank you.
So one has been admitted.
Thank you. Ms. Clark, can you hear me? Ms. Clark, can you hear me? It says you're muted. Staff, would you admit both of them, please? I have maybe she's one line on one foot in 2 different rooms.
That is what we also were wondering.
Yeah.
Hold on, she's actually joining again. Just a moment.
Okay.
And so, yeah. And Alicia.
All right, Ms. Clark, I see that you might be in the room. Are you in?
Mr. Chair, she's muted.
Yeah, I can see you, but we cannot hear you. I have to unmute. Staff, I don't know if you can help her unmute or not.
So, Chair Lindsay, she's actually not muted. She's actually unmuted. So it must be a microphone issue, how it's set up on her end, unfortunately. She can call in on the number that she was texted. There is a phone number she can dial in for the audio.
It looks like she's doing that.
So that means she can hear us, so that's a good sign. Do you want to remove the extra one just so we don't get confused?
Yeah, I think we're pretty clear that it's, I'd hate to cut off something. We just need to hear her, and I think it's pretty clear that it's all her. That one. Like she's calling. There we go. If you can hear us, Miss Clark, they're probably working on getting you admitted. All right. Can you hear us, Miss Clark?
I can hear you. I
can hear you.
So there's.
Can you, Miss Clark, can you turn off the audio on your computer?
There we go. How's that?
There we go. Excellent. Wonderful.
Woo,
The world
success.
is celebrating. Thank you. Ms. Clark, thank you for joining us today. Can you hear me?
I can hear you.
And I can hear you. Welcome. My name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission, and now is the time to hear your matter before us. Investigator Pacheco is going to first provide a report to the commission, and then you will have an opportunity to speak to the commission. And when you do so, we have a super long agenda today, so we ask that you'll be very concise when you do speak to us. And with that said, Investigator Pacheco, please.
Thank you, Chair Lindsay and Commissioners. This is Investigator Deanna Pacheco for the record. Agenda item 64 in your meeting book is a preliminary review report for Debbie Clark, board member for the South County Health District. Following receipt of the preliminary report, Ms. Clark submitted a formal response, which has been provided to the Commission. Based on the information gathered, the Health District owns a dental clinic, which also appears to be part of the district. In addition, Ms. Clark's daughter, Adina Ferguson, is an employee of the dental clinic. In this case, it appears Ms. Clark failed to properly declare a conflict of interest on numerous occasions. Per ORS 244.120 sub 2, when a public official is met with a conflict of interest, they must announce the nature of their conflict, and if actual, they are prohibited from voting on the matter that give rise to the conflict unless their vote is required to meet the minimum vote requirement. In this case, it appears Ms. Clark failed to properly declare the nature of her conflict when she created a feasibility study with her daughter. That included Ms. Clark and her husband's property. In addition, from August 2023 through February 2024, it appears Ms. Clark failed to declare a conflict of interest each time the board discussed her feasibility study, Ms. Clark's property, and her daughter's compensation. Next, per ORS 244.040 sub 1, it is not allowable for a public official to create an opportunity for themselves, a relative, or a business with which they are associated that could result in a financial benefit or detriment. In this case, it appears Ms. Clark used her position to create a feasibility study, which also included her property. Based on review of the meeting materials, Ms. Clark promoted her property to the district board and stated she would provide the district with low interest rate and donated equity. These opportunities were available to her as a board member, and it appears no one from the public was given the same opportunity to promote their property to the district or write a feasibility study that included their own property. Thus, it appears that Ms. Clark used or attempted to use her official position with the district board to financially benefit herself and her husband and secure a $187,000 payment, an opportunity only available because she held her official position. Should this case move to investigation, Commission staff would seek to identify whether Ms. Clark was met with any additional conflicts of interest when working on the district's feasibility report and whether she properly declared her conflicts of interest when addressing her daughter's employment or compensation. The recommendation in your books is to move this case to investigation. Thank you.
Thank you, Investigator Pacheco. Commissioners, any questions that we might have of Investigator Pacheco? Seeing none, Ms. Clark, we look forward to hearing from you now, and we thank you for speaking to us today. Thank you.
Well, I did send in a response, and first of all, the feasibility study was a grant study. It was requested by our grant consultant to help write a grant package, which he would, submit for grants for us. It was not a request to buy my property. It included information about what the consultant called a, oh boy, I should have looked at this closer. It was like a property a property agreement where if the district wanted to have the rights to the property so that they could submit a grant, if they found a grant that required that they have control of a piece of property, it explained how to go about doing that. It was not for them to buy my property. It was just some information about what we had found so far. And what we did was we started out, and when I say we, I mean not Adina and I, but Cherie Kosler and I looked at what was available in town. The Boulder Market was the only property that was actually listed for sale. We looked at possibly the parsonage. We looked at some other things. There was very little property for sale. I mean, Union is very small, has very little commercial property, and a lot of it got bought up during COVID when people decided they wanted to start moving out to Eastern Oregon, so there wasn't much. And the board knew that, because you can tell in the discussion on the audio tape that they understood that I was not asking them to buy anything, that it was just a report, and the consultant was requesting that they pick a piece of property to do a report. They wanted to have an engineering firm do a report and make up a clinic design so that he would have that as part of his grant package. And the whole part about whether we needed to buy a piece of property at that point or what property we were going to buy wasn't even part of the discussion. It was just, will you pick some property for us to do a study on? And they did pick the Boulder Market. I did declare my conflict. The board is well aware of my conflict. I mean, we're a town of 3,000 people. And my husband and I have done business here for 30 years. So everybody knew who I was. I declared it. They picked it. They continued to talk about, they would put the discussion of actually buying a property off until later. Then in September, when Mr. Hawkins was doing his presentation and was clearly upset about even considering the Boulder Market, after the meeting, I did three things. I officially sent a memo to the president removing the Boulder property for consideration in their property search. And I put the property back on the market. It hadn't been on the, anyway. And I requested that another board member, Kathy Kirby, take my place doing any property searches or whatever. So at that point, I completely backed out of the whole thing. There's some other things in there. The investigator said I was profiting from grants, and that's not true. I wasn't writing any federal grants, and there weren't any grants being written to purchase property. Said something about a sales proposal with preferential tax treatment. I didn't write the sales proposal. The real estate agents did, and they gave it to our attorney, and our attorney approved it. Let's see. I went through the tapes and the minutes myself, and there are places where the board was talking about informational things, because like I said, I was not a party to looking for the property after September, and they were giving reports and stuff, and I did not declare my conflict of interest, and this could be an issue on my part where because my understanding of the law was that you declare your conflict of interest when you are going to talk about taking action on it. So, when we were going to take action, I did declare my conflict. And then, so there could be some disconnect there. I don't know. And also I didn't, like I said, if somebody was doing something informational, I did not declare my conflict, but I didn't have anything to do with any of it. Kathy Kirby and Adina did the property search. Adina did all of the work on getting the information for the actual grant submission, hired the experts, the engineering firm, the real estate people. It was all done by professionals. And during this whole process, because Mr. Hawkins was constantly, bringing up conflict of interest and whatever, we contacted the attorney, Eileen Eakins, who's our attorney for the district, and got help from her. I called the hotline for the Ethics Commission. I talked to Susan Myers in October. Maya Lefevre, our compliance officer, talked to Susan in November, December, I don't remember. And I also talked to a local person here who is he does compliance with the state. Like he goes to the city and checks to see how they're handling different things. And he didn't see a problem with it, and our attorney didn't see a problem with the ultimate purchase of the property. So that's kind of where I'm at. I mean, I did everything I could to try to not make this any kind of violation or problem for the district.
Okay. Thank you. Commissioners, any questions of Ms. Clark?
I have a couple questions, Mr.
Yeah,
Chair.
go ahead, Commissioner Thompson.
Two questions. First, Ms. Clark, can you tell us a little about the reporting relationship? Who does your daughter report to? How does that work?
Adina reports directly to the board.
Okay. My second question is, I just want to confirm this. You mentioned it in your report that the current health clinic or the current dental clinic is in a building that's managed by a board that includes Mr. Hawkins' wife?
Yes, that's true.
Okay, thank you.
Mr. Chair, just a quick additional question. We have the communication from Ms. Clark we received. Thank you for Mr. Pacheco or whoever did for emailing it to us. That is undated. I'm going to presume that arrived after the end of your preliminary review. Am I right?
That is correct, Vice Chair Fisco.
And this may be an unfair question, and if it is, don't answer it. Armed with the information you have in this report, would that change your view?
Thank you for the question. Simply put, no, it would not change the recommendation of the preliminary report.
Thank you. Thank you. I wish this would have arrived in a timely fashion, but that can be said a lot of things when, I suppose, a piece of good news is we now have 60 days, not just 30, but that's a different point.
Okay, go ahead, Susan.
Chair, could I clarify a couple things? Yes, I recall speaking with both Ms. Clark and another person. This was not recently. This would have, in my recollection, been 2020, 2021-ish. I recall speaking specifically to Ms. Clark about the fact that Mr. Hawkins' wife was on the board of the entity that owned the building they were in. That entity is itself a governmental body, and so it did not create, and my advice to them was that that did not create a conflict of interest for Mr. Hawkins because government bodies are not businesses with which we're associated. the other extent of any conflict of interest advice I recall giving to Ms. Clark or whoever the other person who called was simply advice on here's how conflicts of interest work. If you are going to be making a decision, recommendation, or taking any action that could result in a financial benefit, you need to take the steps to make the appropriate disclosure.
Okay. All right, commissioners, any other questions of Ms. Clark? Seeing none, we need to make a decision whether we proceed with investigation or not. Is anybody prepared to make a motion or desire to make a motion?
Mr. Chair, I will, as the vice chair, yield to my colleagues on this issue. Just make a quick comment. I fear, as in some cases before us, this may be an issue where we're asked to insert ourselves into a very local dispute of sorts. If that's a bad label, I apologize for it as I make the comment. My second free comments is the fact that an attorney was consulted here, and I'm not exactly sure how in every respect is an issue for me. And then lastly, this doesn't strike me as an issue that connotes or carries a huge ethical dimension to it. So I'm prepared to dismiss, but I will yield to colleagues. Thank you, Mr. Chair.
Mr. Chair.
Commissioner Thompson, go ahead.
Mr. Chair, I'm similar to Vice Chair Fiscom's comments. The building issue to me is something that I'm just not interested in. I mean, I think that you've got two groups that control buildings fighting over where this clinic's going to go, and I'm not interested in the commission being part of that discussion. Whether we dismiss or not this case, I am a little concerned about Ms. Clark's daughter reporting directly to a board on which she serves. And I say that knowing that in a small town of 3,000 people that might be a problem. But I think that maybe this organization could benefit by putting in place some policies and procedures to deal with that issue. I'm not saying it can't happen. I'm saying that maybe there needs to be a more formalized policy on how this will be dealt with because that situation exists.
Right. Okay. Looks like, Commissioner Newell.
Commissioner Newell.
Thank you, Chair. I'll say that similar to other cases we've seen today and in the past, there are a lot of moving parts in this. There's a lot of issues that arise because it is localized and you have people stepping up to, help out the community by becoming public officials, and they're wearing other hats at the same time. And that creates these issues and conflicts that are arising. I think it's a really great opportunity for some significant training to come in. I think that there is a need to clarify where the fault lines are here and where the issues are so that we can focus in on what it is that needs to be remedied in this local area with this group of folks so that they don't come back here again with these kind of issues. And so I would be supporting moving it forward in order to have that opportunity for further education and clarification on where the issues are.
Thank you. I've asked if anybody's prepared to make a motion. I think that's the first clear indicator that I've seen. Are you prepared to make a motion, Commissioner Newell?
Give me one moment. I will be.
Number 4.
Number 4. All right. Chair, I hereby move the commission find there's a substantial objective basis for believing that Deborah Clark may have violated ORS 244040 sub 1 and ORS 244120 sub 2, and that the commission should investigate accordingly.
Thank you. Commissioners, we have a motion before us. Any comment on Commissioner Newell's motion? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCully,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiska,
No.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-1.
Thank you. Ms. Clark, we have decided to move forward with an investigation. I want to make clear we have not made a determination that you have violated anything. We have simply made a decision to proceed further in investigating this a little bit further and to gather some additional facts before we make any sort of decision. So with that said, we appreciate you being with us today. Our staff will be in contact, and we wish you a wonderful weekend.
Thank you very much. And I look forward to your help, your assistance in this.
Thank you very much.
Thank you.
All right, staff, or commissioners and staff, we now have agenda item 65 before us. Ms. Schwartzler and staff, if you'll let us know when she's in.
Okay, she is joining us.
Hello?
Hi, Ms. Schwartzler, can you see and hear me? I can see and hear you.
Yes, I can. Thank you.
And am I saying your name correctly, Schwartzler?
Yes.
Okay, wonderful. My name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission, and now is the opportunity to have your matter heard before the commission. We're first going to have Investigator Sullivan give a report to us as a commission. And then after Investigator Sullivan, you will have an opportunity to speak to us. We have a super long agenda today, so we ask that you be as precise and concise as you can be when it's your turn to speak. And with that said, we'll now turn to Investigator Sullivan, please.
Yes, thank you, Chair Lindsay and Commission. This is Investigator Josh Sullivan for the record. I'm presenting agenda item number 65. This is a complaint against Kate Schwarzler, City Councilor for the City of Independence and former board member of the Independence Parks and Recreation Committee and Independence Planning Commission. The complaint alleges that Ms. Schwarzler may have attempted to use her position for financial gain and may have failed to publicly announce a conflict of interest. Ms. Schwarzler is the owner of two Independence businesses, Indie Commons, which is a shared marketplace and event workspace, and Creo Commons, which is a consulting company. She's also the executive director of Indie Idea Hub, a nonprofit organization which provides entrepreneurial support to local businesses. In this case, Ms. Schwarzler's business, Indie Commons, received $280 from the City of Independence on April 30th, 2024, when the city purchased items to be included in gift baskets, which were later presented at a city event called the Main Street Conference. Ms. Schwarzler stated that she was part of a group of city officials who had input about what items were to be included in the gift baskets, and she made a recommendation to the city's economic development director. Several of these items were selected and ultimately purchased at the Indie Commons marketplace. Ms. Schwarzler did not publicly declare a conflict of interest and refrained from discussing the matter. Instead, she recommended selecting items from businesses within Indie Commons. By doing so, Ms. Schwarzler took an action in her official capacity that financially benefited her business. Therefore, it appears she may have violated the conflict of interest provisions as described in ORS 244120 sub 2 and may have engaged in a prohibited use of office in violation of ORS 244040 sub 1. Based on the information in the report, there appears to be a substantial objective basis to believe that Ms. Schwarzler may have violated the above the conflict of interest and prohibited use of office provisions of Oregon government ethics law. Yeah, that's it. Thank you.
Okay, thank you. And to cut to Vice Chair Fiscum, if we were to move to investigation, what would you seek to discover?
Yes. So some of the background work. I did talking to the community, the city's economic development director, and getting the invoices from the city, and that work has been done. Just kind of identifying some of the surrounding circumstances and probably pursuing a letter of education in this matter.
Okay. Thank you, commissioners. Any questions of Investigator Sullivan, please? Commissioner Newell.
Thank you. From what it sounds like, Indy Commons has retailers located within it.
Right.
Those retailers are not Ms. Schwarzler.
Correct. So
Do we know what the actual amount she benefited from versus her retailers?
yeah, so the $280 was the amount that she benefited from. The retailers would have benefited a different amount.
Do we know that?
The retailers that are not her businesses, I don't know that amount.
Okay. Okay, because it says Indy Commons received 280 from Independence when it purchased the items. And so I would like some clarification on whether that 280 is for her or whether it was a flow through back through her to the retailers. And so it sounds like your position right now is that the 280 is for her business, not a flow through to the
It
retailers.
was a check written to her business.
Okay. And a separate check was written to the retailers?
I guess that would be something that we would look into.
Okay. Thank you.
Commissioners, any other questions of Investigator Sullivan? All right, seeing none, Ms. Schwartzer, now is your opportunity to address us. Again, we do remind you to be as concise as you can, and please go ahead.
Yes, thank you. I do have a couple of points of clarification. The first one is that the event in question was not for the Main Street Conference. That was in October of 2023, and Indy Commons did not supply any gift basket items for that particular event. This was for the governor's conference on tourism, which was in April of 24. So I just wanted to clarify that. I also want to state that I was approached by the City of Independence to source items for their gift bags that they were putting together for attendees that came out to do a tour. We discussed different options on Main Street. The work that we do through Indie Idea Hub and Indie Commons, we support local businesses, and so we have a good handle on what are products that are made there within Independence. So we discussed other retailers. At the end, I was directed by Sean Irvine that he did want to proceed with purchasing items through Indie Commons. Of the $280, we only keep 10%, which is to help cover credit card processing fees and some small marketing fees. The rest of that money is then passed on to the people that make those products. In this case, it was a company that makes local kombucha and another company that made cake pops. So that's the points that I want to clarify.
Okay, thank you. Commissioners, any questions of City Councilor Schwartzler, please? Okay, seeing none, it's now time to make a decision whether we want to dismiss or whether we want to proceed preliminary review to an investigation. Are there any commissioners that are prepared to comment or make a motion? Seeing none, I'll express my position. I just think there needs to be some facts ironed out and clarification, and therefore I would support a motion to proceed to investigation. And anybody oppose that or have an alternate motion?
Mr. Chair, thank you for your comments. I'll just make the motion. I hereby move that the commission find there is a substantial objective basis for believing that Kate Schwartzler may have violated ORS 244.040 sub 1 and ORS 244.120 sub 2, and that the commission should investigate accordingly. I would add, I think there are a few facts to be ironed out, and this appears to be the way to do so. Thank you.
Thank you.
Mr. Chair.
Commissioners, any comments? Commissioner Thompson?
Chair, I think that some facts need to be ironed out here, and I think this would benefit Councilor Schwartz, but it's not lost on me that this is an election. This is shortly before an election on which Ms. Schwartz is on the ballot. So I renew my objection to the commission being drug into political matters, and I feel like we are in this case again. So.
Thank you.
Mr. Chair, I would concur with my friend Commissioner Thompson and simply underline what you often do in such votes as this, which is that if we were to proceed today, subject to a vote yet to come, that it is not a finding of a violation, ethics violation, and that is a very critical distinction with an election coming up. So thank you, Mr. Chair.
Thank you. Any other comments, commissioners? Seeing none, we'll call for the vote, please.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 8-0.
Thank you. Councilor Schwartzler, just to confirm, we have decided to move from a preliminary review to investigation. As Vice Chair Fiscum said, we have not decided or determined that there's any violation. So with that said, staff will be in touch with you shortly, and we appreciate you being with us today, and we wish you a wonderful weekend.
Thank you. You too.
Thank you. Okay, before we move on to the next items, I just wanted to see how we're doing lunch-wise. What's timing-wise, Susan?
The lunch has been delivered, so if you want to take a 5 or so minute break, we could get it distributed.
And have a working luncheon?
Yeah.
Okay. I'm inclined to do that. This next item, just so you know, commissioners, we're going to hear agenda items 66 through 68 and 70 through 71 together. So those are five agenda items. I suspect that's going to take at least 15 minutes to handle. So why don't we grab your lunches, and then we'll do a working lunch through these items. Does that work?
Yeah.
Yeah. So let's go ahead. We'll reconvene in 7 minutes. We'll reconvene right at about noon. Okay. Thank you. Hi, Shanoa and Alicia. It looks like we're the room's getting in order over there.
Can you guys hear me? My office internet just went out, and so now I'm hotspotting.
Yep, you can hear just fine. There's no difference at all.
Okay, great.
I think it's everywhere. I got kicked off a little bit ago, so. Pesky internet.
Live and die by it.
Commissioner Lindsay, the folks that were joining for the next group, they were online before we went on our break. They have dropped and we're trying to get them back online now.
Okay. I assume we'll just wait. We'll just wait while we're getting them back online.
Yeah. And I think everyone's having internet problems. To comment on other commissioners, we've had multiple journalists and respondents drop and have to rejoin a lot. So you are not alone.
You still online, Alicia?
Say that again? I'm here. Yep, I'm here.
Okay, thank you. I see you. I just didn't know if your audio was on.
I'm
Thank
good.
you. Thank you.
Susan, while we work to get them online, do we want to move on to 69 where the fact pattern is slightly different? It's 69 and 81 and then come back to the others. That would work.
69 and which number?
And 81.
They're together?
Yeah. Casey will be able to.
Together and separate.
Okay.
Separate.
So
Yeah.
Say that again.
No, same motion, different reason.
Oh, we do have the respondent for 66 online now.
69.
Okay, 66 is online now.
They have full.
Share what you got.
There was a.
You should have heard that.
Okay, so we have
Oh, so
66.
she's
and-
going to be a move to dismiss
Yes,
also.
yep.
So 66 is online. 71.
71 we have not had any response for, and we're trying to get 70 back online as well. So if you want to do 69 first, we could do that and then invite the others in.
All right. Yeah, let's do that. Let's do 69 and maybe even 81 because neither of those guys are attending.
Okay, so
Or everybody's now here for 66 through 71, right?
That is correct.
Okay, let's just do that. Okay.
Okay, so we'll let
71.
we will let the respondents for 66 through 71 in.
Okay.
Excluding 69.
That is correct.
All right. Hello, Miss Adams. I can see you. I cannot hear you. Looks like you're muted.
There, I think I'm unmuted now.
Great. I can see and hear you now. And
Good.
then let's see here. It's 66, Miss Mitchell. Are you, it looks like you're on. Can you hear me?
Yes, I can hear you.
Okay, wonderful. Thank you. All right, so commissioners, before us, we have agenda item 66 regarding Don Mitchell, who is appearing, 67, Larry Johnson, who's not appearing, 68, Rob Younger, who is not appearing, 70, Charlene Adams, who is online, and then Jim Yon, who is not attending. They've waived confidentiality, and Miss Adams and Miss Mitchell, my name is Sean Lindsay. I'm the chair of the Oregon Government Ethics Commission. And now is the time to hear your matters before us. What's going to happen procedurally is investigator Fenstermaker is going to give a report to the commission. And the commission may or may not have questions of the investigator, and then it will be your opportunity to respond and to give statement to the commission. We may or may not have questions of you as well. After we've heard, then we will make a decision whether to dismiss these matters or to proceed from preliminary review into a formal investigation. We are not going to make a decision today whether there has been a violation. We're just going to make a decision whether there's substantial information to proceed to an investigation or not. And finally, when it is your turn to speak, we do have a super long agenda today, and so we had asked that you be very concise in your statements. And with that said, Investigator Fenstermaker, please.
Thank you, Chair Lindsay. Commissioners, I'm Casey Fenstermaker. Agenda items 66, 67, 68, 70, and 71 are preliminary review reports for the members of the Board of Directors of the Sweet Home Fire and Ambulance District. Each of the members waived confidentiality. The complainant in this matter alleged that the district conducted an executive session on April 16th, 2024, which was to discuss potential litigation, but that no attorney was present. The complainant also alleged that the district failed to post its agendas, meeting minutes, and meeting notices to their website. On April 16th, 2024, the district held an executive session pursuant to ORS 192.660 sub 2 sub H, which allows a governing body to hold an executive session to discuss current litigation or litigation likely to be filed. The district's counsel participated in the executive session by telephone. However, it appears that during that executive session, the district and their counsel discussed unfair labor practice complaints. The Attorney General has determined that unfair labor practice complaints do not constitute current litigation or litigation likely to be filed because they are part of an administrative proceeding as opposed to litigation. Based on the information reviewed, it appears that the district should have held the executive session pursuant to ORS 192.660 sub 2 sub F, which allows a governing body to consider information or records that are exempt by law from public inspection, which includes legal advice. Additionally, the public meetings law requires a governing body to give public notice reasonably calculated to give interested persons actual notice of the time and place of the regular meeting, as well as a list of principal subjects anticipated to be considered at that meeting. The law does not specify where the notice is to be posted and does not require that the meeting notice be posted on the